We acknowledge the traditional owners of the country on which we are speaking today, the Gadigal people of the Eora Nation. We wish to recognise and respect their continuing connection to land, culture and community. We pay our respects to their elders, both past and present, and extend that respect to other Aboriginal people listening. This podcast represents a brief summary of the law relating to the issues raised and should not be relied on as a substitute for professional advice. Specific legal advice should always be sought in relation to any particular circumstances, and no liability will be accepted for any losses incurred as a result of reliance on this podcast by those relying solely on this podcast. Hello and welcome to Hicksons Health Hour, the podcast series that explores a variety of current legal health topics. Throughout each episode, you will hear from different members of our health team who have expertise in this area. We hope that you enjoy the podcasts and find these episodes valuable. Hello, my name is Rosslyn Cooke and I'm a partner in the health team at Hicksons Lawyers. Today, I'll be discussing privacy and confidentiality. I will be unpacking how the operation of legislation and local policies affect you as health professionals and what you do with personal information of the patients you treat. Australia has a complicated landscape of privacy laws. It's chock-a-block full of legislation, but that being the case, it may surprise you to know that Australia was behind the rest of the world in introducing privacy laws. Historically, Germany and France were some of the first countries to introduce privacy laws. Germany introduced its first privacy law in 1970 and France in 1979. Other countries like Greece, Korea and Italy embodied privacy laws in their constitutions. Like Australia, Japan introduced privacy laws in 1988. Iceland, New Zealand, Portugal and Poland were all behind Australia in introducing privacy laws. You could say that, being a slow starter to the world of privacy legislation, once Australia got off the blocks, it fully embraced privacy laws and introduced a lot of legislation. It introduced the Privacy Act in 1988 and its amendments, including the Notifiable Data Breaches Act in 2017. There are a great many other health-related privacy laws, such as the National Health Act, which regulates privacy to do with Medicare and the Pharmaceutical Benefits Scheme. There is also the Healthcare Identifiers Act of 2010 about investigation of complaints about handling of healthcare identifiers. There is also the Electronic Health Records, which are governed by the Personally Controlled Electronic Health Records Act 2012, under which my health records were rolled out federally. These are just a few of the very crowded landscape of privacy laws in Australia. The main piece of legislation relevant to the work you do is the Health Records and Information Privacy Act 2002. This is the seminal piece of legislation for your work. This act specifically relates to health information, privacy in New South Wales, and is also of greatest relevance to what you do in your day-to-day contact with personal information. The Act outlines how you, as health service providers, manage the health information of the New South Wales public. The Act applies to health service providers who handle health information. It includes public and private organisations that provide health services and collect, hold or use information. The ambit is broad. It applies to organisations as diverse as universities that undertake research, gymnasiums that record information about a gym goer's health, or private health practitioners, as well as public health organisations and their staff, you. This Act governs the collection, storage and use of personal information via the privacy protection principles, which I will discuss shortly. Under this Act, if an individual is not satisfied with the outcome of a privacy internal review, or their application is not dealt with in 60 days of receipt of the application by the agency, they can apply to NCAT for a review. That is the New South Wales Civil and Administrative Tribunal. So what we're talking about here is health information. What is health information? It is personal information or an opinion about a person's physical or mental health or disability, or a person's express wishes about the future provision of health services for themselves, or a health service provided or yet to be provided to a person. It can include genetic information about a person that predicts or could predict their future health or that of their genetic relatives. This Act that we're talking about establishes the position of the New South Wales Privacy Commissioner. The Act governs the powers the Privacy Commissioner has, which are to investigate and conciliate complaints. The New South Wales Privacy Commissioner established 15 health privacy principles. These are said to be the key to understanding the Act. They establish legal duties that describe what New South Wales public sector agencies and their staff must do when they handle personal health information. The health privacy principles will be relevant to how you interact with patients and meet their information needs. Now, there are 15 health privacy principles, so without running through all 15 of the health privacy principles, I believe the principles which you will find most important in your day-to-day practice will be your use of a patient's personal information and deciding when and how to share that information. These principles are contained in the health privacy principles dealing with accuracy, use, disclosure, and transfer of information. I will go to these most relevant principles rather than running through all 15. The first one that I think is of great use to you is the health privacy principle of accuracy. You must ensure the health information that you record about a patient is accurate and relevant before being used. That brings us to the next most important health privacy principle, which is use. And I must stress that use of a patient's health information is limited. An agency can only use health information for the purpose for which it was collected or a directly related purpose that you and the patient would expect. Otherwise, separate consent is required from the patient. Now, another very important health privacy principle is disclosure. Disclosure is limited and you can only disclose health information for the purpose for which it was collected or a directly related purpose that you would expect. So for both use and disclosure, you can only use that information for the purpose it was collected or a directly related purpose. Otherwise, separate consent of the patient must be obtained. The final of those 4 important health-related principles for you are transferals and linkage. What you should know is that transfer of health information is controlled and limited. You can only transfer health information outside of New South Wales in accordance with the health-related principles. The health privacy principles ensure that health information is relevant, accurate, up to date, and not excessive. Make sure when you're obtaining personal health information that it does not intrude into the personal affairs of a patient, and only collect the health information from the person concerned unless it is impractical to do so. The use and disclosure rules are possibly the most important rules to get across, as this is the area where practitioners are most likely to be dealing with personal health information. As I said before, it's so important to remember that you can only use health information for the purpose for which it was collected, or a directly related purpose, which the patient would have expected, unless one of the exemptions applies. Aha, you say. Exemptions, that's the first you've heard of that. Well, yes, there are exemptions. These exemptions are for your use and disclosure of personal health information, and here are the main exemptions. First of all, consent. You can use private health information of an individual if that patient consented to a secondary use of disclosure. Another exception is reasonable expectation. If the individual would reasonably expect the secondary use and disclosure of the information, and it is directly related to the primary purpose for which it was collected, you can use the information in that way. Another exception is requirement by law. You can use or disclose the personal health information if it is required by law, for instance, to respond to a legal claim or a subpoena. Finally, there is another very interesting but relevant exception, and that is if there is a serious threat to life. The use or disclosure of personal health information may be disseminated if it is required to lessen or prevent a serious threat to life, health, or safety. So they are the main exceptions. Here's what you cannot do with personal health information. And there's a long list, so listen up. You cannot use health information in several ways. First of all, do not disseminate personal health information to third parties. Don't take photographs on your mobile phone of a patient's body. Don't share photos, records, or other personal information for anything other than an allowable purpose under those health privacy principles. i.e., do not share photos, records, or information in ways the individual would not expect, unless an exemption applies. Don't lose personal health information, and I can't tell you how often that happens. Yes, it is easy to lose health information. Please make it secure. Don't write a letter to a third party in which you refer to additional information about a patient. For example, a doctor wrote a letter of support for a patient addressed to police in which the ex-husband's medical history was set out. The doctor accessed the ex-husband's medical history through the EMR. A complaint was made, it was investigated, and the hospital was required to give a written apology. Only release that part of the personal health information which relates to the request. For example, a father's request for release of records of his children, which revealed information concerning his former wife. A complaint was made by the former wife. The complaint was taken to the tribunal, and the tribunal held that the hospital was only authorised to release that part of the record that contained the children's health record. It was not permitted to release that part of the children's health record which contained the former wife's health information, if it was not also the children's health information. Another piece of advice, don't release personal information from which an adverse ancillary result could follow. For example, a slip of the tongue. A social worker made comment to a property manager about where a former patient's wife lived, which made it evident she was breaching a term of the property lease. This case also went to the tribunal, which found that the hospital inappropriately disclosed personal information, and the hospital had to pay compensation for psychological harm caused to the person concerned, the former patient's wife. Don't use health records of others for personal purposes. I know this might sound obvious, but here's a real case example. A nurse accessed a computer that had been logged on by another employee and left unattended. The nurse then used the computer to access records of other individuals with whom he was in a legal dispute. He then passed the information to his lawyer, and it was subsequently used in his legal proceedings. The nurse was suspended and ordered to pay the HCCC's costs. Don't look up health records out of interest or inappropriately access health records. For example, in South Australia in 2016, employed public health staff were found to have accessed the clinical records of Cy Walsh, who at the time had been charged with the murder of his father, Phil Walsh, the coach of the Adelaide Crows. South Australia Health investigated and 21 staff were found to have inappropriately accessed information. 2 had their employment terminated. Disclosure and breaches of privacy principles is the next topic I want to talk to you about. Accidentally providing personal information to an unintended recipient is so easy to do by simply sending the information to an incorrect email address. And can I say this happens more often than you would think. Revealing personal information in the course of a conversation with a person outside the entity is also something which could easily happen quite inadvertently. For example, the slip of the tongue. Displaying a computer screen with patient information is so easy to do, but should not be done. These are all examples of disclosure, and I would suggest are breaches of privacy principles. Local health districts engage in voluntary reporting of data breaches. This allows the Privacy Commissioner to assess the breach, provide advice, or investigate. The health sector was the highest reporting sector in the period January to July 2020, reporting 22% of all breaches to the Privacy Commissioner. So what obligations are imposed by the local health districts? New South Wales Health staff have obligations pursuant to the Code of Conduct and contractual obligations through your employment contract. Generally speaking, you may only view, access, use, and disclose personal health information when it is necessary for you to do so to carry out your work duties. New South Wales Health and local health districts have a zero tolerance for breach of privacy laws. Regular audits are carried out to determine if records are being properly accessed, used, and disclosed. Furthermore, all suspected breaches of patient privacy are investigated. The basic principle is that health workers, you, are not to go into the EMR unless you are delivering healthcare. The only exceptions are for research or education. Both exceptions must be evidenced by proper documentation. So what happens if there is a privacy breach? Broadly speaking, the investigation procedure follows this course. The complainant is contacted about the alleged unauthorised access to the EMR. This could be a staff member who reported the suspected breach. An audit is carried out to determine who accessed the EMR at the time of the alleged breach. This will involve Workplace providing a list of staff who worked on the days the alleged breach took place. The investigators will speak to staff to determine who legitimately accessed the EMR and who did not. For the remainder of staff, the investigation will focus on whether they had any reasonable reason to have accessed the EMR or dealing with those staff who admitted they had no legitimate reason. The consequences can be enormous. There could be notification to the Privacy Commissioner, notification to the patient. The Privacy Commissioner sometimes directs that the patient should be notified. If the patient is not satisfied with the way the breach or the complaint were dealt with, an application to the New South Wales Civil and Administrative Tribunal can be made, or there can be a referral of relevant staff to the HCCC. Personal consequences to a staff member who has breached privacy can also include that you will receive a letter to inform you that the breach of privacy has been determined and the breach will be recorded on your HR record, or the full gamut of HR disciplinary options are available, including and up to dismissal. I want to go back to one area where breaches of privacy are very fraught, and this is the issue of photographs. Photographs are a serious privacy issue. Do not take or store photographs of patients on your mobile phone. This is a privacy breach. Use the camera on the ward if photographs have to be taken. Speak to the ward manager to ensure the camera is ready to be used if you anticipate you may need it, and please obtain the consent of the patient. Consent is essential to take a photograph of a patient. There are processes set out in the Privacy Handbook about what you need to cover off when obtaining consent for photographs. Speak to the privacy officer at your facility if you have any concerns about what is required. Now, what I want to speak about still relates to photographs, and that is the circumstances and information which needs to be conveyed to the patient when obtaining consent to take a photo. This includes how the photos might be taken, how the images might be used in the short term, and how the images might be used and stored in the future. Can I please suggest that you do not take or store photographs of patients on your mobile phone or iPad, regardless of any security settings you may have put in place for the device. Intimate photos have been an issue in the past in health facilities. The Brianna Rose case raised the issue of image-based abuse in Australia. The facts are, in the Brianna Rose case, that whilst the patient was under general anaesthetic, a photograph of the patient's genitalia was taken. This was taken not for pornographic purposes, but for a bit of fun. The photo was taken by a nurse, and this occurred in 2015. The hospital was obliged to inform Brianna Rose of the privacy breach, but under laws at that time in 2015, there were no criminal consequences. However, there were other consequences, which I'll come to in a moment. Let me just say about image-based abuse in Australia that 1 in 5 Australians report having faced this type of image-based abuse, which is a startling fact. Men and women are equally affected. In the disability sector, 1 in 2 Australians with a disability report being the victim of image-based abuse. The figure is same for Indigenous Australians and higher for the LGBTI community. Attacks on human dignity and sexual integrity only attracted criminal consequences depending on what was in the mind of the person taking and sharing the photo. In the Brianna Rose case, the nurse who took the photo had no criminal intent. As a result of the Brianna Rose case, a new act was brought into effect. The Privacy Notifiable Breaches Act of 2016 was enacted following a groundswell of outrage at this breach of privacy case. The main thrust of the Act is that it introduces mandatory eligible data breach provisions, which means that it is now mandatory to report to the Privacy Commissioner certain privacy breaches, such as what occurred in the Brianna Rose case. The law requires you to maintain a patient's privacy. This comes from privacy laws, ethical and professional obligations, and your employment contract obligations. You risk real sanctions if you breach the privacy of a patient, which could result in a civil claim against you, a court order that you pay compensation and costs, perhaps disciplinary proceedings, which could result in you not being permitted to re-register for a period of time, or a suspension by your professional body. There will no doubt be LHD investigations and possibly suspension or termination of your employment. Privacy and breach of privacy provisions is a very important area of your practice. So please familiarise yourself with the health privacy principles, protect your patient's privacy, and if in doubt, seek the advice of your local LHD privacy officer. That concludes this episode of Hicksons Health Hour. Thanks for listening. We hope you enjoyed this episode. Make sure you listen to the rest of the series. If you would like to find out more, please visit hicksons.com.au.